Well, I guess it's our last day here at the old Darrell Brooks show. Let's see what happened this morning. I kind of already know a few things. I don't want to give away any spoilers, but let's just watch it unfold.
And I don't believe there's any reasonable reading of this post that would lead someone to believe that it's for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Thank you. I appreciate the additional record.
Can I say something, Your Honor?
Go ahead.
Just briefly skimming through it.
This is yesterday. Hang on.
I do want to state for the record that I have no involvement with this. I'm
Go ahead today.
really like shocked like this even came to light. I will say,
Give me a second. Let me try to find the right one real quick. That's not what I was looking for. I had a malfunction with my laptop earlier. Crap. I'm having trouble finding it. God damn it. Here we go.
Circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50
Yesterday again. Alright, I think this is it.
charges connected with this case.
Here we go. Slow start. Sorry. Had trouble finding stuff.
Today, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open and the jurors are here, and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post, that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding, based on news reports, that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So
go ahead.
So it's being called a prank.
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things, and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties.
Judge.
Yes.
Oh, go ahead.
No.
Go ahead.
I'm still very concerned about this whole Reddit thing after having the chance to fully read it and look at some of the language that's in it. It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like, Your Honor, to, if it pleases the court, and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the in regards to
I thought he didn't have subject
the language, I also want to state that for the record, this did not come about from the prosecution side, from the defensive side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that
But now are you gonna?
I was the last one to learn of this information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor,
address that for you right now if you would like.
yeah. If it pleases you, Your Honor, I would like to request some alternatives to this issue.
Yeah, we know.
What's your specific request?
My specific request would be to look into a mistrial, and also any alternatives along those lines, short of that, or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody.
Whose fault is that, buddy?
And as you know, because of my status here in the jail, allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
Oh, you found some stuff though.
One being
nice.
United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion, and I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to the language is basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES 917 F2D 388.
Hurry it up.
And that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497. And that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury, which may be tainted by bias. And I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this. And certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language, it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, I'm
in the courtroom every day.
Directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then they quoted, going back to some of these, of having knowledge of is extremely concerning. Talks about
no. What happened here?
Something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options, look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. if anything, for cautionary reasons, I believe, Your Honor, that you definitely should
All right.
take a look at everything I'm
They will respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start, and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue was put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever this thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, let me address your concern, sir. I cannot make conclusions at this point about whether this is legitimate or prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I and I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post, it was an anonymous post, that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you, though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the Clerk of Court's office receive emails regarding this, it sounds like the district attorney received emails. I may have even gotten one, I don't remember the time, it was later, regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it, and I simply forwarded that email onto law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. Right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record.
Oh, yeah, he's back in orange today.
There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out even when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record? That
your choice should be placed on the record.
If not, I was offered to be in street clothes if I made it the choice.
Do you dispute?
All right, so what she's trying to say is that they may come out before their deliberations are done and have questions that she may have to answer in front of them with him present. And she's given him the opportunity to continue to not look like a criminal. Unless he's trying to use this for his own advantage, I don't know why he doesn't understand the benefit of this to his what do you want to call it, to his character?
Dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no, do you dispute that you were given the choice this morning?
At this point, there's no reason why that should be on the record, that if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if we were to challenge that you and claim that you are required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
All right. At this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record yet? And I object.
Yeah. We've heard that. All right, let's go find where our next piece of stuff is. Oh, look. I saw for a second there he put on a suit and tie.
In a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter. And without anything further, I'll have the jury brought out.
All right.
Your Honor, I don't consent to being called their name. I would like to address subject matter jurisdiction for the record that has yet to be proven.
Your objections are noted. I will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Nope. Find and gag him, will you?
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
Yep. Is he going to get removed today? Let's take a bet before it's too late. I haven't watched this.
Your Honor, is that attached to the agreement? Not to address subject matter jurisdiction for the record.
It ain't gonna happen.
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. We will not be addressing that further.
For the record, may I respectfully
shut the fuck
reject
up.
that ruling and take exception to that ruling, Your Honor.
I don't give a fuck. Shut the fuck up.
Is that attached to the agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor?
He is so tired of this guy.
For the record, may I request the legal or factual basis for your ruling, Your Honor?
Nope.
It might have been a false alarm.
For the record, may I respectfully
Would be
request
yours.
a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant? You don't have to address admiralty law or common law.
Well, you're
This
gonna
court is
look
operating
a
under
lot
admiralty law.
We will not be
After
addressing
being
any of
general
those
population.
issues.
Respectfully
Thank you, everyone.
object,
Please
Your
be
Honor.
seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? All right, and I see it's jury number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
It's going to take a while for me to read it. I mean, we all know how this ends, right? I'm not spoiling anything, but we all know how it ends. Just because we're not stupid. I bet you'd be really good at playing the guitar or the bass. You know, with those things. Give that. You have to work at it. And not-
Your Honor, seeing as that we've reached the verdict, is it necessary that I have these shock devices on my ankles?
Find and gag. Where's the find and gag? Can we not do that anymore? Let it be shown that the defense had to be bound and gagged for us to proceed. Yeah, it's a big stack, dude. 76 papers, man. 76 count. 76 people you hurt. Yeah, let's put these all in order. Oh, she's looking good today, especially. She's wearing contacts. She's got makeup done a little bit extra. Judge looks good. She's ready to hand out this. Let's go! Go, Darrell! Come on! You're so boned. You're so boned. I know the outcome, and I know... but we all knew the outcome anyway. We're just waiting for it. Because he's been begging for it. Suspense kills me. They know how
That I have each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that.
Wait, what was that? What was that? Hold up.
Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do
God said burn in hell, you piece of shit. Fuck yeah.
That. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. Dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety?
Darrell Brooks has committed suicide
Yes.
after senselessly beating himself.
Guilty of first-degree recklessly endangering safety as charged in count 13 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
You know
Answer,
he did.
yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 16 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant guilty of first-degree recklessly endangering safety as charged in count 17 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering? We, the jury, as charged, did the defendant, yes, by the foreperson of first-degree using intent 1 degree. We, the jury, charged in commit first-degree. The jury in count 20, first-degree. We, the jury, charged in count commit 50 as defendant commits recklessly endangering person. Yes, first-degree signed by the answer. First-degree date signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 29 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
believe that he
Answer,
got found
yes.
guilty on all counts.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 30 of the information. Dated today's date, signed by the foreperson. Did the defendant commit first-degree? Defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information. Dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information. Dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information. Dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes.
I woke up this morning, they said, "How was your breakfast?" Maybe it was pretty
We, the
good,
jury,
dude. We
find the
all
defendant,
yeah,
Darrell E.
yeah.
Brooks,
All right, cool.
guilty of hit and run as charged in count 72 of the information. Dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information. Dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? We, the jury, for jury 75. We count 76. You individually decide in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first so it's a little bit easier. So juror number 11. Were the verdicts read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts? Yes. Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27. The verdicts read in open court, are those your true verdicts? Yes. Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts? Yes. Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 50. Thank you. I should state certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
The court is so satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There's no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please. Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today,
I guess he is
the court will
gonna get
enter
judgment
judgments
today.
of conviction based upon the verdicts on all 76 counts. Court will also revoke bond. In this case, I plan on bringing the case in Monday, this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf. If so, how many? how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon case.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That helps us in our planning.
All right. All right then. Thank you, everyone. We are adjourned for today. We'll see you all on Monday.
I don't think there's anything else. There's some press conference stuff. We'll put that on. Sure, why not?
I know. I'm just already giving you grief, man. Like, your idea one is.
Somebody didn't bring their recording. Thank you. Very good. AMBE.
Can't hear shit unless they're in front of a microphone.
You're ready. Everyone, we're here to have a press conference to discuss some of the events that happened today. Speaking today will be District Attorney Sue Opper, Chief Dan Thompson of the Waukesha Police Department, also David Sorensen, which is the husband of Virginia Ginny Sorensen, Tyler Pudliner, he's a Waukesha South band member, and Amber Conkey, a mother of one of the juvenile victims. Also present with us today is County Executive Paul Farrell, the prosecution team consisting of Leslie Basie, Zach Witchow, Detective Tom Casey from the Waukesha Police Department, Detective Ryan Rugland from the Waukesha Sheriff's Office, and paralegal Christy Giese. Also to my right, your left, is Jen Dunn and Carrie Peterson from the Waukesha County District Attorney Victim Witness, and with our comfort dog Pepper, who have played an integral role with our crime victims throughout this whole process. To that, Sue Opper.
Thank you. First and foremost, our thoughts and concerns remain with the victims involved in this tragedy and their families. Although the defendant devastated our community, the people of the city of Waukesha, Waukesha County, and beyond demonstrated tremendous resiliency. We are so grateful for the first responders, citizens, and medical professionals who sprang into action and immediately rendered aid and saved so many lives that day. We appreciate the jury for their work and dedication to justice. We commend the police officers and citizen witnesses who testified or were prepared to testify and asked to relive the events of that horrific day. We are satisfied that this defendant has been held accountable for his actions. He now faces imprisonment of 6 consecutive life sentences plus 859 years of confinement. There is much healing ahead for the victims and for our community, but we hope today's result is a step further along that path. Remain strong, Waukesha. Thank you.
Waukesha Police Chief Dan Thompson.
Thank you. 2 days we'll never forget. November 21 of 2021, on that tragic day, and October 26th of 2022. Why October 26th? Because justice was served today. I want to say thank you and praises to this community. I want to say thank you in the resiliency and strength of the families and victims who were involved in it and were impacted by this event. The investigation team, I want to send a personal thank you to the District Attorney's Office, Sue Opper, Leslie, Zach, and everyone on that team who assisted in this successful prosecution. I want to say thank you to the jury and the court process and the court proceedings and everyone that's involved in the court who found this defendant guilty, which is just and right. That defendant's actions did not define this great community. It refined us in our resolve and our strength in being Waukesha strong. Thank you.
David.
Okay. Thank you. I'm David Sorensen. These are my 2 sons. Justice was served for my wife, Virginia Sorensen. my 3 children, and the whole Sorensen clan. Thank you very much to the people that did this court case. We appreciate it. Sean or Marsha wants to say one little thing.
We've been praying for this day for a long time, and this morning my 5-year-old daughter came up to me and handed me this necklace with my mom's ashes in it, and she told me to take my mom with us for the sentencing. So she was with us today, and I just want to thank everyone for what they did today. And one last thing, my mom always used to tell us when we were kids in our family that she always said, angels watch over you guys. So I just want to say angels watch over you guys and turn on those blue lights tonight.
Except for that guy. Burn in hell, you piece of shit!
I want to first thank the prosecution team. They were the one that got us to this point. I'm thankful for all their support along the way and getting us to this day. It's been a difficult day. I know that this will give us healing. This is another step forward in this process. We've been resilient all the way through. One of the things that I've said so much throughout this is that we're stronger than him, and it's been proven today. It's just another step forward in the process. So I want to thank Sue, Zach, Leslie, all those guys for their hard work, Jen and her staff, and especially those first responders. It's been brought up. They are the ones that especially kept me here, gave us a second chance, and they've kept our community strong. So yeah, Waukesha strong. As Marshall said, he touched on it. Keep those blue lights on tonight. Thank you, everybody.
Just want to say that I'm very happy with the verdicts and that justice has been served today. I would just like to thank everybody, the first responders, the DA and the judge, all the law enforcement, everybody who was involved, especially those who were very much involved with my family and the support system that we have had. It's been amazing to see how wonderful this community has been to pull together for all of those who were hurt that night.
Thank you. With that, we'll take a few questions. Those available for questions will be Chief Thompson and District Attorney Sue Opper. So I'll start right here, TMJ4. Would you like to direct your question to? Sue, come on up.
Okay, thank you.
Chief.
We just got to know, how are you and your team feeling right now about this happening?
Well, it's obviously quite satisfying that Mr. Brooks has been found guilty and held accountable for his actions. As many of these victims have said, this is a joyous day for that reason. It's also the point where we hope everyone can move on from. The support that we've gotten as this case wore on day after day was tremendous, and we're very relieved. I guess that's the best word, is relief.
Hillary?
I saw you get a tear in your eye when they were talking about Virginia's ashes. You spoke about
Yep.
what this meant to you and the victims. How do you begin to describe what it was like going up against Brooks as defending him, representing himself? Did that change your strategy? How did you get through all that?
Yeah. I mean, legally it changed our strategy, certainly, because if there's an appeal, he can make a mistake in the courtroom and get a new trial, and we have to pay the price for that, we the state and we the victims. So it changed our strategy in that we had to make sure, and Judge Darrell did as well, the record was very thorough, very complete, and we didn't miss anything. But as far as handling the actual court proceedings, we felt very, very offended by his behavior, his disrespect of the court, the decorum, the families, his insulting the judge, his challenging the judge. That's not the way our system is designed. That was intentional on his part. We truly believe that. He did everything he can except claim that the dog ate his homework. And he tried to turn this into his story. Let's talk about Mr. Brooks and his family. And we just kept redirecting it back to the real focus here is our families, our victims, our community, and his responsibility for this destruction.
58.
What was the most challenging part, and how did you keep your patience through all of it?
Again, it wasn't a difficult case factually, and I don't mean to sound, overly confident in that, but this case was unique because the activity was videotaped, right? And so, whereas most cases we have to rely on eyewitness accounts or other ways to prove the case, we had videograph evidence of his behavior all up and down that crime scene and throughout the neighborhood. So that way, it wasn't difficult. Again, the difficulty and the challenges we faced was what nonsense was going to come out of his mouth next, And
nonsense was gonna come out of
we
his
were
mouth
anticipating much of what would come next and being ready legally with case law and legal authority to be able to respond to that. So I think that was the hardest thing. The investigation was so thorough, so well done that we knew the facts were solid. It was just making sure the record and the presentation was done legally accurate.
We'll do Fox Local.
So what went into your decision to perhaps minimize the number of direct witnesses that went up on that stand? And I wonder, did you expect any of these antics, and if that went into your decision?
Yes, it did. So obviously we didn't know until very late that he'd be representing himself. But we as a team set out from day one, and this was months and months ago when he still had attorneys, we vowed we would not put children on the stand. Absolutely. It wasn't necessary. Again, there were plenty of other ways to tell this story without asking a child to testify in a courtroom and relive this very, very extreme, tragic situation. So that was a commitment we made as a team months ago, and we stuck by that. Certainly, as we learned his antics, we reevaluated, and we would discuss it every night as a team: is who are we going to use tomorrow, and do we really need this person? Because we were so, again, not personally offended, but professionally offended that he would insult the process and insult the victims, accuse them of financial gain for their testimony, things like that. It was just so offensive that we definitely were conscious of that in our decision making and how can we minimize this for the best of everyone, but still provide a compelling story. So yes, it did definitely play a factor.
Court TV.
Thank you so much. Ms. Hopper, there were so many victims' families inside the courtroom every day sitting behind you. How much did that motivate you and your team and how you present your evidence and your closing argument? You mentioned them. And have you been able to speak to any of them that aren't here that maybe said something to you afterwards?
Yes. The motivation we received from those families was tremendous. And we knew, again, from the point when Mr. Brooks chose to represent himself, this was going to be a marathon. We talked about that many times as a team, that we just need to keep moving forward every day, whatever that looked like. But what motivated us was these families that are behind me, a lot of them. And we thought of those mothers and fathers sitting in hospital rooms with their children and the ongoing care that they're still physically healing from and certainly emotionally healing from. And that motivated us tremendously. But you couldn't meet a nicer group of people. I mean, that's the thing is, I'm not surprised, having lived in Waukesha for 35 years, that they're good people here. And they would ask us, how are you doing? Do you guys need anything? Which was really phenomenal. They were a tremendous group of people to work for. It was our honor to represent them and be a voice for them in the court.
Andrew Ramos, Metro News. Yesterday, it seemed you threw Darrell Brooks a little bit of a lifeline when it came to presenting his closing argument. It seemed that the judge was going to kind of forfeit his right to do that. What made you go that route to allow him and then just object to what he was saying?
That was strategic for the appeal, to be very blunt. I wasn't throwing a lifeline to Mr. Brooks. I really had no interest in hearing what he had to say because I heard all of his lies and stories so far. So that was just trying to do what was legally required at the moment. And I frankly wasn't sure it was going to work because he was so difficult with Judge Darrell. But in the end, it did work. He got to blurt out what he wanted to blurt, and then the judge struck that from the record, and we were able to move on. So I was glad that that was the result, but we talked about it at the prosecution table and came up with that idea of let's offer this, again, just to protect the record for the appeal.
Jim.
Knowing what you knew going into this with Brooks representing himself, what caught you by surprise when he presented?
Again, his absolute disrespect and dishonor to the victims, the community, and the court process.
I'll do Brian from the Freeman, and then two more we'll do CBS, and then where are you from? Okay, those are the last three, so go Brian, you got one?
There has been some discussion since the verdict was announced that perhaps a decision to represent himself is grounds for appeal. Are you concerned at all about that?
Well, Mr. Brooks has a right to an appeal. Every defendant does. And I fully expect him to take advantage of his rights as a convicted defendant in this case. I am very confident in the record that Judge Darrell made and his decision to represent himself. Yes.
Go ahead.
Hi, CBS News. What do you think about the length of time that the jury took to deliberate? Short, long, surprised?
We were not. We talked about it last night, and frankly, I know a lot of you were here too. We were all, by the time we got to that 8 o'clock mark, we were exhausted. And when they said they wanted to go home and rest, we were thankful, quite frankly, because we all felt the same way. It's such an emotionally draining day. And to get through all that and the nonstop banter from Mr. Brooks, it's taxing. You all witnessed it yourself. So we were grateful. We thought they gave it good thought because They went out around 6:30. Their dinner was there immediately, right? So jurors are human beings. They get a nice meal. They got a little time to talk, and then they decided, let's rest. Let's sleep on it. Always a good option for decision making for anybody, right? Get a good night's sleep on it, and come back the next day. And then, they worked again for about another hour this morning. And with the quality of the investigation in this case, we think the verdict was fair. The timing was spot on.
Go ahead.
There's a lot of people who are here today, of course, but a lot of people who are also at the parade on the day of the parade who aren't here. In closing, what do you want to say to them just at the end of this process?
Well, I hope some of you caught the flavor of that. You cannot imagine until you saw some of those videos how horrific it would have been to stand there and watch that, especially when your children, and some of these witnesses testified to that, they couldn't find their children, right? And that's not just people who were struck. There was many, many citizens who could not find their own child for a period of time. So just unbelievable. But once the car went through and everybody had that initial, the way the citizens of this community punched in, there's no other word for it. The nurses, the doctors, the EMTs, the paramedics, anybody who knew anything about how to apply a Band-Aid walked into that street and treated those people. So that was another source of strength for us, right? Is if they could do that, we can get through this.
As we move on to the next phases of the judicial process, I'm sure that people will be readily available to provide comment as we get into, we have a court hearing on Monday at 1 o'clock, I believe, for scheduling, and I think then we're going to go into the sentencing phase, and we'll know more about that. People here behind me will make themselves available for you, I'm pretty much sure, as this goes on. But as of right now, we're going to end it and allow people to be with their families, and definitely this prosecution team needs some much-needed rest and some time away from this courthouse. So thank you all very much for being here today.
Yay!
If we could make a line so I can allow these people, thank you. It was more so at your camera.
You might be wondering what qualifications I have to be, doing these kinds of things. Watching these law things and reacting the way that I do. I really don't have many qualifications. I do find the law intriguing, and I do like to study it. Well, at least what I can, find out about it, or what's interesting. I like studying criminal behavior, these kinds of things. I work with law enforcement, and really, probably the best qualification that I have is that I actually work with two people from. I have worked with the judge and the county attorney, or district attorney, I'm sorry, who was part of this.
Mr. Ponton, I believe you have a filter turned on in the video settings. You might want to
we're trying to, can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that.
I can see.
I think if you click the up arrow next to this.
Yeah, I live and work with those people. Anyway, that's it for tonight. Hope you guys have had a great time watching this trial. If you have another trial that you would like me to watch, or something that you want me to check out, something you want me to see, I'd say, drop me a line. Let me know what's good. Tell me what I should be checking out and what I should be reacting to, especially with regards to legal stuff. Being not a lawyer, and also not a cat. I'm not a lawyer, but I'm not a cat either. Okay. All right. Cool. We good?